The problem is those who are attracted to the practice of law and those who succeed in it, because it's maybe one and the same, or maybe it's different, are reared on an adversarial approach, right? It's the old game of strongest wins, loser gets nothing. And the whole concept was, and the court system, you all know this well, is that the theory was if you pitted two champions against one another, the truth will out. That was the idea. And you each hired the strongest champion to carry forth your argument. The problem in reality is that there's a huge amount of destruction when you put two champions against one another. We talked about, when I first came in, the issue of matrimonial law. There are little kids involved. You don't want a lot of blood on the battlefield. But that's the way the lawyers are trained. And if they're trained in adversarial world where devil take the hindmost, then the issue is capture everything, lay the entire land to waste. And so that's where you get motions, you get arguments that say, well, you maybe get this, but you're entitled to more. So let's go another round. When an intelligent position would be, that's okay, that's enough, let's press on. They're not trained that way. It's not the way they think, and certainly it's not the way they're compensated. The longer you battle, the more they make. So quite simply, I don't know how you're into this room, what routes you took to be here, but the issue is the reason I got into arbitration and mediation is because I was absolutely pissed off, I'd had it, with the lawsuit game. Anybody who's been around the length of time that I have, Margaret, I've been around longer. And by the way, it's great to see some old friends in the room here, so good stuff. But the issue is when you've been through some lawsuits, which if you're in business much, you know that's going to happen. The order of the universe. And you just get fed up at the way the two lawyers are milking the conflict. It's particularly disheartening when it's a divorce. These two people who were in love, that's why they got married, raised their kids, shared everything, shared their dreams and so on. Who was there saying, you were saying that you've been through divorce, you're remarried, and got the animals and the kids and so on. It's, when you've got broken dreams, there's an expense that you can't put on a balance sheet, is it? And it's tough enough when you've been in, how many people have been in business, in practice, in a partnership? How many of you? Okay. A couple of you know some of the angst that I've personally been through with a couple of bad partners. I've made a lot of money. I've lost a lot of money. The money that I've lost is solely due to bad partners. Not any business decision that I made. Always protected my clients. But when you turn your back on somebody you trust, and it's the et tu, brute, pulling the knife out, you think, holy crap. Did it once, how could I possibly have been caught doing it again? Well, this boy's been up and down about 4 times. I've lost everything about 4 times. So don't get into business with me. I got a bad track record. I had a guy out in Vancouver who said, Alec, there's one thing I really admire about you. And his name's Bob Henderson. This was after the Provident thing, Margaret. And I had dinner with Bob out there a year or 2 ago. And I was waiting for this wonderful accolade that he might throw my way. I said, yes, Bob, what is it? And Henderson, who'd been, I think, vice president of HR at BC Hydro, or one of the big ones, so he's a pretty substantial guy. Henderson says, Alec, you're a survivor. I thought he was going to say something nice. So I guess given the business climate that we've been through and keep going through, maybe that's not such a bad thing. When it comes to divorce, you got to be a survivor. So with that history of business, nationally, internationally, the ups and downs I've been through, partners I've trusted I shouldn't have trusted, been through divorce. After 30 years of marriage, I got divorced. So I've been through it, never figured I'd be going through it. I'd taken all sorts of men and some women through divorce, thought I knew what it was like. Thought I did. You don't have a clue till you've stood in the shoes yourself. It rips your gut out. It's just a horrible, horrible thing. Thank heavens the two of us did it ourselves, and the total legal bill was $2,200. Because Yvonne has said, I made up the thing that said, due to the fact that we've loved one another, we're not going to hire lawyers, we're going to do it ourselves. She actually took the thing before we finally resolved to go for decree nisi. She actually went and saw a lawyer. It cost $2,000. Since that was coming at me, I asked Richard Devon if he wouldn't mind just looking at what we'd done. So he said, fine, that was my $200. But it was basically collaboration between the two divorcing parties that did it. And I still love the woman. She's the mother of my 3 kids. She's now remarried. I'm with somebody else. I mean, God bless her, great gal. Why? Because we didn't go through the bullshit that you go through when you hire the two champions that bring out all the dirt and throw the crap at one another, and you end up, whatever thread there remained between the two of you is rent asunder by that battle. So I'm glad there were no lawyers here, so I don't have to mince my words. So that's why I got into arbitration, when I said, how come in Europe almost half of the disputes are being resolved by arbitration, not by lawsuit? And it's 30% rising in the States. And there's a series of reasons for that, and I'll dance through. So that's why you all know the issue of the end result, that you want to be there because you got to go separately. You can either do it together or you can do it on a contested basis. You've got a little bit of my background. I've done about everything except make and keep money. And I'm actually in the I'm in the process of doing my doctorate now in public administration, and given my age, you wonder why I'm doing that. But I figure it's time we all keep learning. Very important. And it's opening my eyes. I thought I knew a lot of stuff, but wow, when you look at public admin, there's a whole lot that stinks in our system. We're all aware of who was RBC. We're all aware of what the big banks have done and should have been doing. And we're aware of what the legal system is doing and what it's not doing. So there's a whole bunch of real meat in public admin that affects us that is wrong and needs to be addressed. So whether I'll make a difference or not, who knows. The two routes to arrive at the end of divorce. I want to take you into some nuts and bolts on things, but I need to dance through to make sure we've got the common ground. There are only 2 ways of going. And the arbitration, mediation, negotiation route, the collaboration route, is the one where it is far more logical than the two champions who are at great expense fighting for you to leave nothing on the table. Well, life isn't like that. So it's great that we're moving more towards this. But here, this is where the two parties are obviously talking. The reason that you're into a divorce is because you quit talking, likely. Everybody screws up. Everybody screws up. It's what do you do after you screw up? How do you attempt to repair it? That's the measure of the person. So you can get into, in the first round of things, if you look at the 2 buckets of resolving conflict, and there's some great theory in here that I'm going to revisit with you. But the whole idea is you're either working on it together or you're fighting one another. If you're fighting one another, you end up basically into court at huge costs. Emotional costs, financial costs. The other bucket is where there's some form of trust and negotiation that is continuing. So it may take an outsider to have to help negotiate, to act as a bit of a broker on it. And there's a continuum that you look at. And in fact, I'm sorry that we couldn't get into the official Adriel one there, because they've got one chart that really is terrific. May I?
Yeah, that's right.
Catherine's wincing because every time I get to a flip chart, I love it. So here you have litigation at one end, and at the other is simply negotiation. And as you dance through this thing, the degree of communication goes down, and the degree of anger, fight, and cost goes up, right? Isn't that the way it works? Hey, honey, we're not getting along. How about you take half the house, I'll take half the house. You take one dog, I'll take one dog. Goodbye, okay? Yep, done. Everybody's happy. This one, it's, oh, the War of the Roses, right? The War of the Roses. A really funny story. No, because it's real. You all have people who have lived through the War of the Roses. In the final scene where they're swinging from the chandelier and comes down and it kills both of them. I mean, it's fantastic. So this is the War of the Roses. A funny movie that isn't funny. Whoops. And what you have when you dance through this thing, you end up with arbitration before you cross over here. You end up with mediation here. And you've got the different brands of negotiation moving through that. There are huge differences at law between these two before you cross into that one. Now, somebody over here, I think right beside you, Margaret, Bev, you're a mediator.
Yes.
So you can help me with some of this as we go through. Who else is qualified in mediation or arbitration? You are. June. Which?
Mediation.
Okay. Mediation, arbitration. Anybody else? Okay, so I'll expect the two of you to help with the discussion on this, okay? Thank you. So we're going to look at this continuum so that you professionally can use people as you will, and also use the concepts. The difference here, when you cross over to the dark side, is that the two parties do not agree. Here it's joint to some degree or other, and here it's not. And that's when you get into court, that's when you get into champions, that's when you get into these huge costs. But here's one thing that's a fantastic issue about it. Public. The whole idea of our court system to ensure that things are rational and reasonable and accountable is that it's in a public venue. One of the things I love about arbitration is it's behind a locked, closed door. It's in camera. So if you're into arbitration, let's say doing international cases, commercial cases, there may be, Steve Jobs just died last week. Brilliant man. I never met him. But the stuff that they did is phenomenal. And a number of you are likely sitting there with the benefit today. Intellectual property. Internationally, I've done a fair bit of intellectual property work. The last thing that you want is if Catherine and I are having a dispute over who owns the copyright in this, or a patent or trademark. The last thing that we want is one of our enemies sitting inside the courtroom while we're discussing all of the ins and outs of the very thing that is the intellectual property that we're fighting over. Especially this computer code. Because what happens at the end of the court doesn't matter what the two of us have fought over. The enemy has now got it and has run out into the street. Arbitration is private. Mediation is private. But the two are very different. We'll take a look at that in a couple of minutes. So that is, to me, a critical factor. If you don't want the risk of parading your dirty linen out in the street, don't go into litigation in an open court. Now, we know that 90% of cases are resolved before they're settled before they get into the final trial. But what about that 10%? And you don't want to end up there. Now, this to me is one of the most important single slides I put together for you. And it is not in the Adrio's official stuff. This is because of the work that I've done internationally in conflict and resolving conflict. There have been two traditional ways to resolve conflict. Linda, stand up for a second, please. If we're into a battle, guess who's likely going to win?
You'd be surprised.
She'll win because she's smarter and tougher than I am. If it's purely strength, I'll likely beat her. Point is, don't think it. Dominance was the traditional way that conflict was resolved. The bigger, stronger, faster, wealthier one was the one who ultimately took it. So the example that I try to point is with domination. If one wants black and one wants white, if the stronger is black, guess what everybody gets? Black. Why? Because the big boy says black. The little guy who wants white goes, oops, guess I'm screwed. So everybody's got black. Now the thing is that works for the longest time. Until the power seat, like the old lion, until one of the younger lions gets tough enough. You've all seen the National Geographics. At one point, the alpha male gets weaker. And the young one's going to have a go, and one day he'll beat him. It's a matter of time, isn't it? Because you don't remain strong forever. Sparta fell. Rome fell. Looks like the Yanks are falling. Everything has its day. So one day, the weaker will turn the tide. One day, Linda is going to catch Alec off guard. She'll stick the shiv in me. I'm done. So then we'll go to white until somebody beats her. Not a particularly intellectual exercise, but it worked for millennia because that's the way it is. Compromise. Somebody came up with the idea after a while saying, well, we're supposed to be civilized. Let's chat. Let's use our brains. So Linda and I are warring. We sit down and we say, okay, now Alec wants black and she wants white. So we sit and we chat away, and then we say, well, I'll give up my black. And Liz says, well, we'll put them together. We will compromise. So what do we end up with? Gray. And so we walk down the street arm in arm. Isn't this nice? We got gray. Then we trip once in a while. And when we trip, what do we think about? That we're happy with gray? No, we say, son of a bitch, I wanted black. And I got gray. Am I happy now? No. Linda tricks and she says, son of a... I shouldn't say that. Son of a gun. I wanted white, and that idiot beside me made me take gray. How happy is Linda? She's not. Compromise will work by definition for a while until the stream starts pulling the two apart. And if you stop, everybody says, well, now let's compromise on that. And our society thinks that's a good idea. That's crap. Because the actual meaning of the word, stop to think about it, the actual meaning of the word was our integrity was compromise. You know, during the war, something got compromised. That meant the enemy got into it. Compromise is a dirty word, people. It's not a good word. So it's a guaranteed disaster. It's just waiting. So always you got both parties pissed off here. That's a highly technical legal term. So if dominance works as long as the strong party's in charge, it will likely last longer than compromise, because this one is a disaster waiting to crack. So Dr. Mary Follett, in about 1925, female by the way, came up with the answer. And when I first came across this, I thought, it's the same as compromise. It isn't. It isn't. Her argument was, well, if dominance fails one day, compromise will fail soon. There's got to be a better way. And her argument was, Alec and Linda are going to sit down and say, okay, you want white, Alec, you want black. Why is that? And her argument is to dig down. Just keep digging, digging, digging down. And one day you will reach a common ground. Just keep digging till you got it. Then, once you got common ground down there, then you lay it on. One layer and another, but you must be fully agreed each step. You don't move beyond it until you're fully agreed. It's like dating somebody and you map out step by step what you're trying to do in your life together before you get married, start buying assets. None of us was that intelligent. But Mary Follett says, take it a step at a time so that you're in absolute accord, so that when you end up at the final point, you're fully in agreement. Fully. And it may not be black or white or gray. It may be, and I use the example, maybe it's pink polka dots. But we both bought into the ultimate solution. So Dr. Mary Follett, I think, is maybe the best key to your conflict resolution that you're ever going to come up with. So when you're sitting down, crunching the numbers for warring parties, don't just crunch the numbers. Ask them, what are we after here? What are we agreed on? Don't focus on the disagreements. Focus on the agreements. Build that up so you've got some momentum going, and then you start knocking stuff down. We'll get into a couple of case studies in a couple of minutes. So, if there's one thing that you take away from today, take away the importance of Mary Follett's integration. Don't get sidetracked with the other stuff. Litigation, there's nothing new to you here, I don't think. I've mentioned about the adversarial role of the champions. It's a guaranteed loss for somebody. It's the classic old domination thing. There is no compromise here, there's no integration. This is age-old medieval approach to resolving conflict. Courts now in different jurisdictions are pretty much forcing mediation. At times, and you two mediators help me with this, at times you think, oh, some cold vodka. At times you wonder, how idiotic is that? Simply because if you got two people, if Linda and I aren't getting along well in the first place, so now we're into battle, now we've got the lawyers retained, we're into examination discovery, we're pulled in our financial divorce specialists, and the numbers are flying all over the place, and suddenly the judge says, time out, thou shalt now go to mediation. What's changed here? Are magically the two of us who have not been communicating, that's why we're in this mess, correct? If we were communicating, we wouldn't be in this mess. We'd be talking through it. So if we're not communicating, now all of a sudden the judge says, stop the legal process, you'll now go off to mediation. Where's the wisdom of that? Where is the wisdom of that? If they have not actively sought out somebody to help them over this communication hump, they haven't done that already, why is it going to be Christmas now just because the judge said it? That's why I didn't go into mediation. That's why I went into arbitration, because I figured if they haven't got their act together on their own, They want somebody to be sort of a rent-a-judge with more flexible rules, because they haven't resolved it themselves. They've been idiots. They're busy fighting. So, courts are now generally forcing this. There's always an option for arbitration. Now, it's a bit of a scary option, which is why, certainly in commercial law, I'm making sure on all my letters of engagement, whether it's financial planning, strategic planning, whatever it is that I'm doing, I'm a fraud examiner as well, what I do is if there's any dispute under the contract, this shall be resolved by arbitration according to the rules of the Canadian Arbitration Association. Right there, right there. So it's my issues will not end up in court. They're going to be settled by arbitration. Over, done. If I can't get it, somebody else is going to sit there and listen to both arguments, but flexibly, and do it in private. So a summary of arbitration, and the two types, binding or not. Why bother going into non-binding arbitration? What a stupid waste. Let's sit around, open our skirts, show one another everything, and have this guy sit there, or this trio of guys sit there, go through it all, and make a decision, and it's just like mediation. Nobody solved anything. How dumb is that? So, I'm very simple. Arbitration to solve the impasse, make it binding, over and done. Now, the issue is there are all sorts of rules under arbitration. And I can leave some with you. You can write me. You can go onto the website. There are all sorts of rules in arbitration. I'll dance through some of them with you. But it's very different from mediation here and litigation there for these reasons. It's very flexible. We're going to see that it's the same rules of evidence, but they're more leniently applied. For example, hearsay evidence can be admitted in arbitration. Very difficult to admit hearsay in a court of law. The issue of flexibility is terrific because if Linda and I are trying to resolve our differences and we go for arbitration, and somebody says, well, the arbitrator says, geez, I don't know, a case I'm working on right now in BC. This farm that you said you both loved and you've now had to sell and now you're fighting over it. I don't really understand when you're pointing out a couple of these issues and you're trying, who was the evaluator here? You're trying to do an evaluation that's being contested. Let's jump in the cars at 6 o'clock and drive out there and have a look. Where do you hear that in court? Court's in my courtroom, right? That's what the judge says. Bring it all into my courtroom. If it doesn't exist in my courtroom, if it isn't presented evidentially here, it will not be considered. An arbitrator can say, hey, we got a sticking point here. Let's go have a look at it. So we can all drive out and look at it. Very flexible. It's usually faster, cheaper, and certainly more user-friendly. But it's the same rules of evidence. By the way, as we're thrashing through this, our two mediators, if you've got something you jump in and add, terrific. If you've got questions, ask them as we go. Beth.
What are your thoughts about mediators that are also arbitrators? I've heard differing opinions.
Yeah, and may I answer that one right now? Because I'm qualified, I'm certified in arbitration, which is a different approach. It's the same rules that you use, but it's a different process. In fact, I thought that this one would be more rigorous because it's setting me up to be the ultimate decision maker. And here I'm doing a mediation. This divorce in Vancouver right now is in fact a mediation. So the lawyers are pissed off at me because they're shoved away, their clocks can't go on while I'm mediating. And the issue there is, when you talk about these two, I didn't even start as a mediator. I was retained as the financial consultant, as a fraud examiner, by the husband. And when he wrote me my first retainer check of $5,000 while we're sitting out there, true story, he takes his checkbook and he flips it over at the restaurant. This is our first meeting. He'd been referred to me. He writes the check to me, my retainer of $5, and he pulls it off. He gives it to me because there was a certain amount of money that had seemingly disappeared in one chase. And this check fell down. Hey, I may be old, but I'm not blind. And it had $37,000 on it. And I said, oh. He says, oh, that's for my lawyer. I'm dropping it off after I see you. I said, that's a lot of money. He says, Alec, that's one of many. 37, I'm getting 5 Gs. This guy's getting 37, and it's one of many, and he's one half of the fight. And I sat there, I looked at him, and I said, in my inimitable fashion, I said, are you nuts? He says, it is a lot of money, isn't it? I said, you guys should be talking to one another and stopping this. He says, I know I've tried. I says, how hard have you tried? He says, well, the lawyers won't let us talk. I said, bingo, bingo. You and I, they don't want us talking together. Why? Because we might settle. And the gravy train stops. They, of course, don't. My friend, my honorable friend, you know, as they do in court. So the issue there is I started in a very different role, got swung not as arbitrator but as mediator, and it's been an interesting ride. But what you're talking about is when you start with one role and drop into the other. And there's a very specific procedure within the Institute for changing your role. And it must be documented, and the parties must understand if you're going from mediation, you're their buddy that you're chatting there, into arbitrator, you're not anybody's buddy. And one difference that we'll see here is that anything that I hear from one party can be fully confidential. It depends on what the terms of reference are. But if I'm getting close, as I was last night on, there was a telephone call from the female, and I then said, well, if he's not responding, then how be I write a very carefully worded email to him to get him to respond? And I don't have to share any of that. Whereas here, absolutely everything that gets said is on the record. This is off the record and cannot subsequently be used in court, as you both know. So both of these are private as opposed to this is public, but on the record, off the record, and shall ever remain so. Because mediation gives you the wiggle room to try to get the two parties to agree. This one is, we don't need the wiggle room because they're not agreeing. They just don't want to go into this lengthy, drawn-out, expensive process. So we'll get the gavel and go bang at some point. They're putting their faith in this person here. Their faith is in themselves. So you can actually shift horses in midstream, but you must do it with extreme caution because it's a very different process. Does that answer your question? But an excellent question. The background is that there are different courses that lead to the certificate in arbitration or the certificate in mediation. They have to be sanctioned by the Institute. This is, in Ontario, is the body, and there's the governing body in Canada, and then there are international bodies. And then you've got different levels. You've got the arbitration certificate, which I've got. You've got the certified arbitrator designation, which I don't have. And that's 10 court-approved arbitrations. You can also go to York and do the Masters of Law in arbitration, and you don't have to have an LLB to do that. That'll cost you 10 to 14, I think roughly $12,000 to do that, and I think it's run over basically 2 years. But you cannot practice law. You have a limited law degree, but you are not practicing. You're not a member of the bar. So if you really fall in love with arbitration, you want your life to be that, then that's the place to go. This is where I've been screwed. Pay attention here. Screwed a lot. Don't trust the boy. I mean, bad judgments. Make great judgments for clients, but I figure I'm different, right? It's okay. I can break the rules. No. The rules that you adhere to for clients are for a very good reason. Margaret knows me for a long time. Catherine knows me for a long time. You've known me for a long time, Chris. That I, as a former naval officer, I adhere to the rules extremely well for clients. But it's okay for me to cavalier on my own. Boom, I get killed again. So what I thought was, because I told you the issue of lawsuits and why go into arbitration to solve all that crap for clients. They don't tell you when you're going through the process that the only people who get hired for arbitration are ex-judges. That's the way of the world. So you can have all the qualifications that you want in the world, and I got a fair whack of them. Trying to get arbitrations is like pulling teeth. Why? Because the lawyers are involved in the case before it goes to arbitration. And the lawyers want to kiss ass, so what they do is they steer, if there's to be arbitration, they steer it through one of their senior partners' law firm to a guy who had been on the bench as a graduate from that law firm, and now he's retired, now he's setting up shop as an arbitrator. So the way the system works is an old boys network. Would you agree? Agree? It's an old boys network. So I, who is going to be so clever, get all these arbitrations in Canada. The only ones I'm getting are international ones, not here, because they're all sucked up because of the old boys network with retired judges. Pay attention. You gotta play the game. I didn't. Fascinating. So, now that I've bared my soul, I've given you some hints on this. Mediation, arbitration, and court. And I think it's very important that as an advisor that you understand where you're doing your marketing to get additional work and where it's coming at you from by way of referrals. Because here the intermediary, as the mediator, has to be confidential. I told you that nothing can be used in court. Flexibility is key with both of these. Obviously this one's more so because you're not making a decision. It's whatever works for the parties. The parties choose the mediator and they decide the final outcome. The parties do it, not the mediator. He's simply going back and forth, trying to get the parties to chat to one another and remove the obstacles to the communication. And if somebody's being idiotic, saying, you know, don't you think that's kind of extreme? Because if you back him into the corner like that, he may come out fighting, and we're really close to getting this solved. Can you think? Before you press that button on that email that says, you slimy son of a bitch, why don't you hang off a little bit before you press that send button? You know, we're close. Don't get them riled. And that's what's been happening in Vancouver, the other way around. They had a meeting on the 2nd of October, and they were making great progress. And then she said something that he took absolute umbrage with and just flew off. And, oh, gee, I wasn't there. I got feedback on it. So when you move into litigation, you're dealing with, it's a very real lawsuit, absolutely rigid rules, motions, counter motions, and it goes on, and each one of those is costing you thousands of dollars. And the way I liken it is, how many people play tennis? Anybody? You're not sure if you do or you play.
For a long time.
Okay. Now, there are two ways to play tennis. One is to volley, 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 and the game's going really quite well. And the other is to have every shot challenged from the side. So, no, I don't care what the two of you said. That one was in. And they're both saying it was out. So the game stops. Or a soccer match. If the referee gets involved and keeps blowing the whistle on every single play, what kind of a game is that? That's what they do here. These buggers are blowing the whistle on every single play, and they're focused on the rule book. Oh no, you broke that little rule. We got to do it this way. All you want to do is play the game. All you want to do is get divorced and carry on with your life. No. These guys are into playing the rules. And that's why these are kind of neat. They're basically no rules here, and it's fully confidential. Get it settled whatever way you want. Arbitration, they're rules, but they're far less onerous. And they're very flexibly applied. So if you're going back to a soccer match or tennis or a hockey game, they'll see some of the infractions, but they'll let the game continue. Would you agree? So that's why these things are kind of neat. One extreme, other extreme sitting in the middle. I put this one down. I think we've covered some of these with a couple of discussions we've had. With arbitration, you may have the lawyers in attendance, and they will tend to slow things down, but the arbitrator can say, no, we're carrying on anyway. Can overrule the lawyer. There must be full disclosure. Mediation, it's a good idea to have disclosure, but in arbitration it's absolutely forced. I've said that the same rules of evidence, hours of place. You want to get in the car and go have a look, you can. And I've mentioned that. Fully confidential, it's in camera. Another benefit that is unusual with arbitration is that if Linda and I are back to our battle again, we're battling a lot these days, aren't we? We're now into court, and the issue there is, son of a gun, I just ended up in front of a judge whose every single decision goes to the woman. All of them. I couldn't pick them. That was what the court docket was. With arbitration, and the same in a lawsuit with intellectual property as an example. You may get a judge who's never dealt with intellectual property in his entire life. And that's the absolute core of the case. You know, I'd like a Steve Jobs or a Bill Gates sitting on the bench for me on this one, because he'd understand the game. One reason you hire the arbitrator is because he comes into arbitration as an expert in a particular field. So if the two of us are fighting, and back to the farm example, if we want to avoid court, we'll say, okay, let's go to arbitration on this thing. Let's get a guy who's really good. Let's say the business valuations that we have talked about. That the business valuations, you focused on farming properties and horse farms and so on. Hey, I want you as one of my arbitrators, because we don't have to spend a lot of time schooling a person. Already understand the field. So arbitration, you can actually shop for the arbitrators if you're picking one or three. I've never heard of two. It's usually a lead arbitrator and then a panel. And you get somebody who's an expert in the field. Very efficient. And then you just lay the arguments out again in private, and a decent decision is likely going to be rendered. So I think that's a big one. You don't waste time teaching the judge, and run the risk that the guy just doesn't get it, because it could be a decision both parties aren't happy with. I've mentioned in U.S. that it's 30% arbitration, 70%, but declining by suit. Europe's higher. The whole idea of the adversarial one is, to my way of thinking, anathema to solving conflict. So that's exactly how a lawsuit is structured. I mentioned in my contracts, every one of my letters of engagement has this contract stating any conflict will be resolved by arbitration. And I suggest all of you, if you don't have that in now, start putting it in. It's a very simple clause. Here, you both agree on picking the same arbitrator, and if you're going to go for 3, you each pick one, and those guys pick the third one, so that you're guaranteed neutrality in that one. The issue is, notice how subtle I am. Non-binding arbitration is, let me think, how will I phrase that? It's a waste. Okay. Because then you're ending up in court anyway. Why bother? Now, there are various issues here within the framework. There are certain clauses that you're allowed to opt in or opt out of, and there's some that are obligatory. So as you work through your assignment, you want to know what are we opting in and what are we opting out of. I mentioned that divorce is just like any of the business relationships, but there's a little less sex, likely. Sometimes in marriage there isn't much sex after a while anyway. So there are issues there, but partners in business really get very intimate. They know one another's families. The dreams are intertwined. It's just, this dimension is different, but there's that same issue of betrayal and loss, all of the emotions. See, when anger kicks in, you're screwed. Because reason goes out the door. You guys sit there and you do all the calculations that you want in the world, and somebody just isn't listening. I don't care. They say, I don't care. And I can remember somebody properly defined a physical fight, because there's a lot of physical violence in bad marriages. And it's that fists take over when the brain has run out of options. Isn't that neat? It's true. Fists take over when the brain has run out of options. And so don't discount that you're going to deal with somebody who's absolutely illogical. You've got all the best numbers in the world, and somebody just doesn't see it. So back to negotiating versus litigating. If you're going to elect mediation or arbitration, get into the roster, find out who's there, who's specialized in the area that you want, and then get, if it's mediation, the court assigns, they'll pick the existing roster. If you're going through here, make sure you interview several. Obviously, there are sample contracts that the Institute puts out, and you can get samples from them, or you could email me, and I can do that. Cost is an interesting issue. The issue of cost is that the arbitrator tends to get between $300 and $500 on an hourly basis, and that's split between the two parties. Whereas if you deal with legal counsel, it can be $300 to $500 an hour times 2, right? Because if one guy's got his clock on, the other guy's likely got it on either at the same time or in response. And then by the time you add question.
You suggested there should be an interview. Do you charge for people to interview you?
I will give the first half hour. As a potential arbitrator, I will do the first half hour for free, and after that, get your checkbook out. Because I figure in half an hour, I can assess the situation, say whether I'm prepared to take it on. They can assess me whether they're prepared to take me on, and which is different from my financial planning, because I will give the first half hour at half price. So they're paying for me anyway. And after that, you either like enough what you see that I get my full retainer, or you pay me for that half hour at reduced rate. God bless you. So I'm doing it differently here. But when you start adding up the 2 lawyers and assistants, and then you start adding, if there's, I did one case where I was in fact the certified fraud examiner on, and there was one on the other side. So you got 2 certified fraud examiners, you got 2 legal counsel, and backup. Guess what the numbers were there? I mean, pick a number, right? You're into what, a couple of $1,000 an hour? With no guarantee of anything happening except somebody's going to bring a counter motion and challenge something else. It's ridiculous. Plus, they're there to beat the hell out of one another, and the poor family. They are spending the family's money. That's the children's money that's going into... I did one time, it came to me. I picked up a couple of small papers and I folded them in half. And I said, each one of those is a BMW. You know what you 2 are doing? You're giving a brand new BMW to each of your lawyers. Is that what you want to do? What? Well, think about it. That's what you're doing, isn't it? You're giving a brand new BMW to each of the lawyers. Who's paying for that? The children are paying for that, because that's money that isn't there for their education. Sounds like a pretty stupid system to me. Who'd want to be part of that? So that's why we're into collaboration and so on. So you add court reporter and chambers and so on. So arbitration, you got to hire chambers, you use them, and you need a court reporter, obviously, but it's no different than court there, but the prices are a lot cheaper. Time frame. Back to the flexibility. If you want to meet 7 days in a row, you can. You tell me what court will meet on a Saturday. You know one? Or a Sunday? Don't know one. But if it serves the warring parties to try to strike resolution, to meet on Saturday and Sunday and get it over with, the arbitrator is absolutely in his power to say, let's do this. I think that's kind of neat, because the whole purpose is to resolve the conflict, not to drag it out. And it goes on, of course, till the arbitration ends. The decision, interestingly, can be oral or it can be written. But it's rendered quickly. It's none of this, well, let me think about it for about 4 months. Now, but ultimately, because of the way it's structured, even though it's binding arbitration, there's a little escape clause at the tail end in virtually every case that says, if you're really, really bent out of shape, you can still take it back to court. But the chance of that succeeding is so small. If the arbitration's been run well, it's over and done relatively quickly, and it's done. Here's some stuff on the Institute, and I don't think I want to go into that because Linda's going to give me the hook. So it's just, you can go on the website and find out some more about it, mission and so on. I put in about the 4 national arbitration rules, and you can go on the website and see those. And I think if you're going to be getting involved in arbitration, it's good to know the rules that the arbitrator has to run his arbitration by. Now, I can't emphasize this one enough. The issue of flexibility. What drew me to it and why I stay at it is this issue. Section 2 says that the parties can modify the rules. So, if Linda, back to Linda and me, if we're having difficulty, we want to do whatever we possibly can to get on with our lives. We don't want to sit here and be hamstrung by a whole bunch of silly little rules. So when we're sitting down putting things together, we can agree on what the rules of the game are going to be. What judge will let you sit down and say, Judge, I'm going to tell you how you're going to run your court? No, not going to work. So arbitration and mediation has that facility. So back to look at the rules, see what you can do, and see what you can get around. As long as you agree, you can basically do whatever you want. Now here's a little thing I put together. Why you may want to if you, as a financial planner, doing divorce as a specialty, if you want to get into med-arb, there are all sorts of courses that you can do to take it, and you may have the same motives that I have had. If you don't choose to get into it, if you want to simply use it, then I think there's an argument why we who've come from financial planning can be pretty decent in arbitration. And that's because when it comes to finance, which is what you're working with, we know what the models are. We can sit there, we can make our Excel spreadsheet sing. We can tear apart ACPAC statements. We know where the weakness in the new views program is. We know a number of issues. So when it comes to taxation, when it comes to financial statements, when it comes to fraud, when it comes to a whole bunch of issues, we're already there. So if finance is a key part of the conflict, of the dispute, then you maybe want somebody as mediator or as arbitrator who already has that field of specialty. So there's no confusion. Another highly technical legal term, no bullshit. You can cut to the chase, save a whack of money. There's another issue that goes beyond the numbers, isn't there? We understand the psychology behind the numbers. Somebody may be reporting something, but we know what it means behind that. Or if there's a number missing, we know to ask for it. Or somebody's taking a number and extrapolating, we say, no. Future value of money, a little bit different from present value. Thank you very much. We don't like the way you've extended these. You know, you've taken it out 26 years. I think your factor of inflation here is kind of ridiculous. So we can settle on whether there's a truthful, accurate presentation on things, and we got a clue what's going on. I mentioned one case here where I was not involved on it, but I understand that both parties spent over $4 million in legal. $4 million. Now, if I thought 37,000 was nuts, guess what I think here? Holy crap! It's and I know I've met one of them. Arbitration, one of the most famous ones was the Lord Beaverbrook Foundation, where England was fighting, remember, a couple of years ago, was fighting with Prince Edward Island on should it stay there, should they get the paintings back, and so on. And that one went on behind closed doors. And they chose to release some information on consent to the media. Fascinating stuff. When are we pulling the plug?
You're good for it.
What? Another? Okay. I heard another hour? Okay.
We're going into gray now.
Yeah. Forget the polka knot. It's definitely, no, this is domination. She calls a shot. Two that I'm working on are kind of fascinating. The first one is an actor. I can't mention his name, but you might be able to put it together. He's won different awards. Interesting guy. He was sent to me to try to fix it. He was director of a credit union and was under challenge by CRA. And they were concerned that I was called in because they were concerned that he was suicidal. And so I met with a nice man. I asked, where is he standing with his credit cards and his revenuers? He brought out a carton of unopened mail. You've all seen that, right? It's avoidance. He hadn't worked in a bit. He hadn't worked in a bit because his wife was just divorcing, and the reason she was divorcing him was because he had become quite an alcoholic. So I rolled up my sleeves, professional association had retained me to do this because of the man's visibility. And I started chewing through things. Hadn't filed tax returns for a while. So here I'm sitting in a room with repeat national awards, the trophies there, and another national award. So clearly a competent man. Nice man. Anyway, to fast forward the thing, I did what I could. He resigned from the board of the credit union. I felt I couldn't hold the wolves at bay, advised him to go bankrupt, set up the trustee, took him through bankruptcy. He, as part of the process, his wife, now ex-wife, when he hadn't responded to me for a while, he said, Alec, when I drove over, I'm the subject of an intervention. And he was. Wife and daughter had thrown him in the car, took him off, met a shrink, got him installed, and they started working on it. Bottom line was, he quit drinking. I encouraged him. I mean, I'm not trained. I encouraged him to do some marketing stuff, and a few things started happening. And this guy who'd done this ended up, while we're going through the bankruptcy process, he said, Alec, I've just won a contract at Stratford. I said, great, but I didn't hear that. Because a contract means money. And money means bankruptcy problems with the trustee. So I said, I didn't hear that. Have you signed anything as yet? No. I said, don't sign. Wait till we get this resolved. I told him he should have his will done. I get a phone call from the president of the association on the 7th of April saying, he's dead. What? Practicing at Stratford, had a massive heart attack, and died. Now, the reason I tell you this one is because I've ended up on this one not as an official arbitrator, not even as an official mediator. I've been behind the scenes trying to keep the family along. Because his income had done this, he didn't keep up his insurance payments. So his whack of life insurance got sliced down to here. The outstanding issues, because he was at Stratford, hadn't gone to the final meeting of the trustees. His final declaration wasn't through. He was not a discharged bankrupt at the time he died. What does that do to all the debt with CRA and CIBC and so on that I pushed away? It comes right back over the transom. Every penny of it. Because he was not discharged. So suddenly his life insurance that's here is down to here. All of the discharged debt, which I had gone, whoosh, right back. It's okay, we'll check with the will. He didn't get to the lawyer. Now he's died intestate. I now have an on-discharge bankrupt with everything coming back, CRA chasing for on-file tax returns plus accumulated debt. I've got an intestacy, and I got a wife who's a divorcee. So now I've got two kids who are just barely the age of majority, but very immature. Oh my God. Oh my God. So it's a wonderful case in its textbook issues. So I had the sleeves up. They had to feed more money and I had to go in. So I got the trustee. I found a document that he had signed holographically. He'd written a letter, hadn't posted it. At the end of March, just a week before he died, to the trustee to say, I'm sorry I missed the final meeting. I'll be down to Toronto and we'll do that. So I used that as evidence of his intent. So the trustee could say, well, that basically, so it was a stretch. Everything was a stretch. The royalties I had to get held so they wouldn't get sucked into the morass of this thing. And you've got to be very careful. You can't do anything that's illegal, but you must serve the client. And so I found ways to work with the rules, bending them a little bit. The official guardian, we got involved, the public guardian, and said, well, given that the estate's under $10,000, you don't have to do a filing. In fact, you're better that you don't. I got off the record, because that would then bring scrutiny onto things. So I had to keep under the radar with them throughout this whole thing. So when you are doing your number crunching, if your gut is telling you there's something missing, chase it down. Because the one thing left one thing undone can unravel the entire ballgame. I've been telling you a bit about the BC case, and I get the parties together, and then somebody does something stupid, and they go flying apart. And all I can tell them is, thank God you're not into court, because the lawyers would take that and lever that up into another marvelous set of motions and counter motions, and you'd be into the thing for another 50 or 100 grand. There were $1 million paid that they sold one thing, and the two lawyers said, "Oh, we'll take that." I said, "You can't do that. Don't let them do that. We're under mediation now. Get them to release it, because you know what? If it's sitting in the lawyer's trust account, guess what happens to it? They bill against it. They're allowed to bill against money sitting there as a retainer." So what I did is I got 800 grand of the $1 million out by 400. The lawyers were not pleased. So I've got a couple minutes more, I think. I've just got, I want to do a little exercise with you. I've got something here, yeah. It's, when you look at the rules of evidence, they're summarized here in different books. I've done a book and they're summarized there. But I've mentioned about hearsay, I've mentioned about what's on the record, what's off the record. When it comes to the rules of evidence, if you've got documents that you're assessing, you must pay attention to the care, custody, and control, that there's an unbroken chain of that asset or the documents that you're using. Because if they have fallen out of the chain, then they are suspect. And there's specialty things like the Moravian injunction that you can serve to freeze if you're working with a bunch of assets. You may want them frozen so somebody can get at them. And this is a particularly tough order, Anton Peller, which you go in with the boots on and you grab all of the records, all of the computers, and go at it. So you only want to get into that thing if there's a whack of money involved. Now, what I want you to do is I want you to close your eyes for a second. Just sort of lean back, close your eyes. I won't tickle you. And I want you, what I'm going to read to you is the checklist for fraud. And I want you to picture somebody. I'm going to read 12 pairs of words. And I want you to just close your eyes and think of somebody who meets these things. These are the checklist points. Urgency. Think of something that somebody is pushing that they require urgent turnaround. 2, incomplete documentation. Think of somebody that you can't get documents out of for love nor money. Number 3, unwillingness to divulge. They will not tell you the answer to your question, however hard you try. Picture this one, inconsistencies. Who has told you inconsistent stories? Are you getting the same person coming to mind for each of these ones? Number 5, think of somebody who's presented you with numbers and they're out of balance. You can't get these things to balance and you can't figure out why. Next one, think of somebody who has an operation that there is a high staff turnover. Bodies keep coming and going every time you go into the place. Think of one that there's a lot of frenzied or busy activity. Things seem to be frenetic. Well, that may be a sign of fraud. Only 5 more. Threats to get something done. If somebody's pushing you, is threatening you, is putting something at risk for you to get things done, that's a worry. Unwillingness to put matters in writing. If somebody is telling you something, you say, well, Can you just give me a note to that effect or an email? Think of somebody who is refusing to give you something in writing. Third lastly, many staffers from one outside group, you walk into the operation, you're doing your merit calculations, and you find that there's a whole bunch of people, not from different areas of society or different companies, but all from one. It's maybe step. Poor qualifications of many staffers. They're people doing things that you don't think they're qualified to be doing. Think of somebody like that. And the last one, think of somebody where things are quite extreme. They're too extraordinary. It doesn't make sense. If you find any of those issues, for example, some guy who is a clerk in somebody's company, but he's wearing big gold ring and he's got a Rolex on, he's got one of those big gold chains and so on, but he's only a clerk, excuse me, this is inconsistent here. Okay, open your eyes. Did you think of somebody specifically, the same person for more than one of those? Yes? Anybody else? Two? Okay. The first thing you should be questioning in your own mind is there fraud? Because the more of those little red flags that you hit, the more you are being set up. You're working on a set of numbers that maybe stink. So if I'm an arbitrator, I want to know if what's being put before me is something I can stand on, it's solid, or if it's BS. So, I'm just wrapping things up, okay? So, the issue is the evidence for the mediator, there's got to be full content equal to what you have in court. Full and true, the stop must be open, it's got to be frank, there has to be no fear, and remember you cannot use it subsequently in court. That's one of the neatest things about a mediator, is you're free to discuss it openly. Evidence for the arbitrator, the same thing, the court rules. Any evidence can be used. And as financial divorce specialists, one of the classic things that you need to work with is that when we found fraud by my partner in Providence, which was a disastrous thing. I lost all my money at that time too. Every few years I do that. See, I figure it's more fun trying again. I'm an idiot. So anyway, what we did there is I thought, how come the cops have not gone at this thing more aggressively? One of the clients, as you may remember from the papers, one of the clients died during the investigation. But what happened was, and I should have known, but I didn't. The rule of data evidence gathering under the Ontario Securities Act is far broader. Under the Act, compliance and enforcement have greater search and seizure capabilities than do the police. So what the police did is they sat back until the OSC finished their investigation. Why? Because whatever the OSC grabbed and introduced as evidence in front of the tribunal, the police could then use in the subsequent criminal investigation. If they'd done it on their own, they would have been precluded from a whole bunch of things. Clever. You've got to know the rules. Once you know the rules, you can play the game better. I had one judge tell me one time, and I thought it was absolutely fascinating, because different judges will point out that you're really there, and the lawyers will too, in all due fairness, say, just tell your story. That's what you're there to do. You're there to tell your story. Whether you're in front of a mediator, in front of an arbitrator, in front of a judge, tell your story. Just let it flow logically out. But this judge said one time, when I was being attacked by the litigator, I was the testifying fraud examiner, and the litigator was coming hard at me, and it was during examinations for discovery, and and the other certified fraud examiner, who was an internationally highly regarded guy, and I beat him. I was pleased with that. But the judge said as they packed up at the end of discovery and walked out, I was slower to put all my stuff away. The judge sat there and said, which I thought was fantastic, he says, Mr. Wright, don't get sidetracked. Stick to the issues. What fabulous, fabulous advice. Why? Because the lawyer wants to poke you and get you upset so you react and you get off track. So you don't tell your story. That's what they're trying to do. Remember, adversarial, winner take all? That's how that game is played. Whereas in arbitration mediation, you want the full truth to come out so you can properly assess it. Not in court. Totally different process. So I thought this was wonderful. That's another thing that you want to likely tuck away. Tell the story, stick to the issues. So Mary Follett is a key one that I think you want to remember. You want to remember the differences between arbitration and mediation and then lawsuit on the other side. Tell the story, stick to the issues. I think as part of telling the story, one thing that you need to do, if you don't, is tell the story graphically. Judges, arbitrators, mediators absolutely love you to not bury them with a whole bunch of words or a whole bunch of numbers. Give me a picture that tells me what's going on here, please. So you can take Excel, build your charts and your graphs, and make it as simple as you possibly can, because you're telling the story. That's what you want to get across, is the story. And you must show anything that you're bringing forth, you must show that it is relevant and it's material. Don't bore the arbitrator or the mediator or the judge with a bunch of fancy BS. They see right through it. In fact, most people who are mediators, judges, or arbitrators are relatively clever people. They're going to see through the crap. They like honesty and clarity. I think I've only got a couple more, right?
Yeah.
I think that if you put yourself into the headset here, everybody in this room is here because they believe in the collaboration, in the truth, in the honesty. That's why you're here. You want the numbers to fairly present what it is that you're trying to resolve. And so this mindset is one that's very important. And the mindset of your two warring parties must be to let's get settlement as soon and as reasonably as possible. Don't fight over the last 10% that's on the table, because 50% of your bill will be over the last 10%. Just cut and deal with it. Life will, you need to heal. You need to move on with your life. That's the story you have to get through to your clients. Because every time, when my wife, my first wife, Catherine, we know Ivana, when Ivana had been fired unfairly, we said it was so disastrous to her emotionally, we said, you got to sue. You know, you have to sue to get yourself back hold of this thing. This was purely political. So we did sue, but it went on for a long time. And every time a letter came in from Osler Hospital, it would come in and sit, because it was like ripping the scab off again. Isn't it? It's like that. It reopens the wound that's starting to heal, because you're right back revisiting the stuff. So it's very important to finish it and move on. The lawyers don't want it to finish. Why? They stop getting paid. And you know when the lawyers phone you and say, we should settle? When do they do that? And they do it time and again. When have you been told by your client that the lawyer has just said it's just wrong and said we should settle? When is it? When the money's all gone. The lawyer says, I think really we should settle, Bronwyn. And Bronwyn says, well, that's what I've been telling you for the last year. I've been prepared to settle. Oh yeah, but we have to now. There's no money. So as long as the pie is there to be divvied up, they're going to be fighting over it. adversarial, right? It stinks. It's wrong. The way we're trying to do it makes far more sense.
2 minutes.
2 minutes? Okay. I've mentioned about Mary Follett. If you're into stretching your brain with different ways of resolving conflict, Schelling's book on the strategy of conflict is one that I think is an absolute standby. And it gets into how to play the mind games and what goes on. And then the three that are the classics for dealing with strategy in conflict, and everybody knows Machiavelli's The Prince. How many have actually read it as opposed to heard about it? Just 2 of us? When you read, 3 of us. When you read it, it's totally different from what you thought it was, right? Totally different. Everybody's misunderstood Machiavelli. Poor old Nicole. They don't understand. Sun Tzu, a number of people have heard about this, The Art of War. How old is this one? 2,500 years old. It's required reading by most of the militaries in the world today, 2,500 years later. And why I commend it to you is because a divorce is the same thing as a war, just a little less blood. Sometimes not, a lot less. This one nobody knows about. And this is absolutely powerful. Miyamoto Musashi's Book of 5 Rings, it was written within 40 years or so of Machiavelli, halfway around the world. This guy was the top samurai warrior of all time. When we were kids, let me finish this and you can kick me off. Okay. When we were kids, certainly us guys, I don't know if you ladies did, but we all played cowboys and Indians, right? And the whole trick was you pull the gun out and you quick draw and you shoot the other guy. And if you figure you got him, you were supposed to file a notch in the gun. Do you remember that as kids? You don't remember that. Come on. You remember your brothers do it. File a notch. And the big thing was, and when you watch Gunsmoke and James Arness and all of the shows, the big thing was the guy had 5 notches on his gun. Holy crap. What a man. He stood there 20 or 30 feet from somebody else 5 times and he won this gun battle to the death. What a guy. Isn't that what we all thought? Incredible. What a mensch. This guy. Not a gun. It was a blade. He would stand there as a samurai warrior. This is little. Carry it all the time. And it's the blade that's the sharpest blade known to man. You talk about conflict and divorce, this is the ultimate. So they would stand a blade's length away, and they might circle for hours and hours. Not a couple minutes with a guy with a gun, but hours. And you know what? Who won? The guy who struck first? No. The guy who struck first always died. Whack! Because he struck out of weakness. Think of that when you're dealing with conflict resolution. You know how many notches in his gun equivalent the samurai warrior had? 4 or 5? Remember, battle to the death, blade sharpest known to man, an arm's length away. Makes your skin crawl. 62 times he did that. Not 5 or 6 with a gun 20 feet away. Whoa! This was right close up, man, right in your face, moving around. Remember the game of Blink as kids? You don't remember that?
Oh, Blink, yes.
Huh? Stare, the first one to blink. Oh, you're good. I tried to cheat and you still beat me. This is Blink, because it's brinkmanship. That's what the lawyers do. They play the games and they fight. Collaboration is the opposite. It's working together to solve a problem. So if you want to study human nature and conflict, these guys had it nailed. Absolutely fascinating how to understand the human mind when it's in conflict. Now, I think this is my last... Oh, okay, I've got the 2. In working on my doctorate right now, I've taken on an assignment to do research, and I'm off in the bush So I've got my financial planning clients, I've tried to ease off while I get this addressed. And I'm the principal of a school that is possibly the most troubled reserve in Canada. They've got a high rate of suicide, of shootings, of HIV, and so on. So I'm principal of the school to try to bring order in it while I study, gather stuff in public policy, because it's out in the middle of nowhere. And it's like a small city with small numbers, so I can look at the public policy and how the implications are in the pure. But it's absolutely fascinating. They get their unemployment, or their 80% unemployment, and they're all drunk, including my teaching staff. And I've never seen anything like it in my life. So I've got all sorts of raw material for my research. But, in fact, I was home 2 nights ago for the first time in 2 months. So, because they got an apartment for me up there. But I've been out moose hunting and so on. But here's something that's useful to us in arbitration, mediation, and divorce settlement. Our First Nations people have a thing that they call the talking stick. How many people know about the talking stick? Oh, terrific. Because while I'm holding the talking stick, nobody interrupts me. I'm also supposed to speak the truth, and I'm supposed to speak it without anger. So people respect me and my words. And as long as I'm holding the talking stick, nobody can interrupt me. But the moment I'm finished, and I pass the talking stick, I'm not doing it yet because I got one. When I pass it over, I now have to similarly respect the wisdom and the truth and the words. Medicine wheel. And it talks about the 4 directions of the earth, and I don't know how well it's come. Is it? So it was hard for me to get a higher quality one than this. But if you read the words on this, your idea about collaborative law is brilliant, because we have shat upon our First Nations people like you wouldn't believe. I'm seeing it now firsthand. And it's remarkable what we've done to them. No wonder they're in such trouble. So you will see that from an abused, and it's usually the wife, an abused wife will evidence exactly the same behavior that I'm seeing, this defeatist attitude. They've been crushed so long, they have no fight left in them. It's unbelievable. So the idea of the medicine... Okay, God bless you. I think you're doing some absolutely important work, vital, vital work. Keep it up. And remember what I said about the adversarial thing. Get your clients away from that as fast as you can, because it's unbelievably destructive. All you got to do is think of that. The War of the Roses. So thank you all.